This is the matter of the state of Minnesota and Deirdre Evavold, HACR 154227. We are scheduled for sentencing here today. Counsel, please note your appearance.
Kathy Keena on behalf of the state.
And Ms. Evavold, you continue to represent yourself, is that correct?
Correct.
All right. Is the state ready to proceed to sentencing?
It is, Your Honor.
The record should reflect that Ms. Evavold was found guilty following a jury trial of all 6 counts in the complaint, each being counts of deprivation of parental or custodial rights involving 2 minor children, SVR and GJR. I ordered a pre-sentence investigation following the verdict. Ms. Evavold declined to participate in the pre-sentence investigation process and did not cooperate with the probation department in the pre-sentence investigation.
I did cooperate with that. I have the right to remain silent, so I did meet with the probation officer.
And the probation department did file a very what's called a non-compliant PSI report, followed by an addendum detailing the severity level of the offenses and the Minnesota sentencing guidelines criteria for these offenses. So, Ms. Keenan, you may proceed.
Thank you, Your Honor. Your Honor, the state just received the addendum to the PSI this morning. I'm not sure that Ms. Evavold has received a copy or not.
Did you receive a copy of the PSI addendum, Ms. Evavold?
No.
Okay, I can provide you with a copy of that.
There's this.
Could you print it out? Thank you. The record should reflect that Ms. Evavold was provided a copy of the PSI addendum. She has had the opportunity to review it at council table and has now looked up from reviewing the document. So we will proceed with sentencing. Ms. Keenan.
Thank you, Your Honor. Your Honor, in reviewing the addendum to the PSI, I believe there are some corrections necessary in regards to the counts that convictions could be entered in on. And again, this is very confusing. It's often thought that it's the girls that are the victims in this case, and while they are victims for purposes of the crime are actually Tammy Love and David Rucki, because it was their rights that were deprived. So with that basis, the state is asking that the court enter convictions on count 1, which is deprivation involving David Rucki, and count 3, which is deprivation involving Tammy Love. As to the sentence that the state believes the defendant should receive in this case, it's the state's position that Ms. Evavold should be treated the same and receive the same sentence that Sandra Grazzini-Rucki received in her case. This defendant was the nexus between Sandra Grazzini-Rucki and the Dollins. She's the one, the defendant is the one that found the location for the girls. She knew of the location. She knew that the girls' father was desperately seeking their return. She knew law enforcement was seeking their return and actively searching for the girls. She attended family court hearings in the Rucki dissolution matter. She knew Judge Knudsen had ordered the parties to provide any information they had about the whereabouts of the girls. This defendant has very close ties to Michelle McDonald, who was representing Sandra Grazzini-Rucki in those dissolution proceedings. She had all that information. She knew everybody was looking for those girls, but yet for 2.5 years, she remained purposefully silent. And why she remained silent and her rationale for doing so, I think, is more reprehensible than actions taken by Sandra Grazzini-Rucki. This defendant did it purposely for her ideological beliefs about the family court system and her complete disregard for the family court system, and used the Rucki family and specifically those girls to try to prove a point. And for that, she ought to be punished just as harshly as the mother was. So with that, the state is asking the court to enter convictions on the 2 counts. On count 1, the state is requesting that she be sentenced to a stay of execution of 1 year and 1 day, and that she be placed on probation for a period of 3 years. On count 3, the state is requesting that she receive a stay of execution of 1 year and 1 day, and that she be placed on probation consecutively to the probationary term in count 1. The state is requesting that the court follow the other recommendations set forth in the amended PSI with a few minor modifications. The first recommendation is that she serve 180 days in jail and that she be given credit for 44 days served. The state is asking that the court impose that. In number 2, the probation department is recommending that she serve 15 days in jail commencing on April 19th, 2018, and that she serve 15 days in jail every year that she's on probation. The state would request that that be modified so that she is serving 15, or actually to be equivalent to what Ms. Grazzini-Rucki received, it would be 12 days. And that actually be commenced on November 18th, 2017, which is the anniversary date of the girls' recovery. That she also be required to complete 10 days of STS each year for each year that she's on probation, and that be completed by November 17th of each year. That she pay a fine of $944. that she pay restitution in the amount of $10,000 to the Crime Victim Reparations Board, joint and several with her co-defendants. That restitution be reserved for any expenses related to David Rucki and Tammy Love, as well as the affected children, for any therapy costs, counseling costs, and that also be joint and several with her co-defendants. That the court specifically authorized that restitution be paid prior to any other court-ordered financial obligations. That she not have any direct or indirect contact with David Rucki or Tammy Love or the two girls. That she have no direct or indirect contact with any of the co-defendants, which is currently a condition of her release. That she abide by any active orders for protection, harassment restraining orders, and no contact orders. That she have no assaultive or threatening behavior, specifically that she not engage in any harassing behavior towards David Rucki, Tammy Love, or any of the other, or the Rucki children. As this court has been advised, this defendant has engaged in internet harassing activity with this family. It's my belief that she released to, I'm not going to mention any names, but she did release the video of Samantha Rucki's interview and her transcript, and that was posted on the website. And it's that kind of harassing behavior that I'm trying to get her to stop doing. That she complete a forensic psychological evaluation and abide by any of the recommendations. That she complete a cognitive skills evaluation and follow recommendations. That she fully cooperate with the transfer of her probation to her county of residence. One thing that wasn't included in the recommendations that the state is requesting is that the defendant be prohibited from acting as an advocate in any dissolution proceedings in which child custody is in dispute. And then finally, that she follow the other standard conditions of probation.
Ms. Evavold, what, if anything, would you like to tell me before I sentence you?
Well, a fair trial includes the right to present a complete defense. I was made aware that I was also not provided with information on Christina Fox, all of the investigative data. I completed a consent form that was given to Stearns County to have that released, and that was willfully refused to be provided to my husband. So I didn't receive any of the preliminary audio statements on any of the witnesses, so I wasn't given the fair trial and able to complete a defense.
Is there anything else?
Also the witness tampering, that I was attempted to file a report on that, and with Samantha, that she was brought in and encouraged to alter her testimony, and that's a serious offense. So I'm requesting that I be given a fair trial, a new trial, to be able to have the evidence, review it thoroughly, and be able to use it to my benefit.
Do you wish to respond to the request for a new trial this time?
Your Honor, the defendant did receive a fair trial in this matter. It was her actions and her inaction in not wanting to participate under this false belief that she did not receive all the discovery in this case. She received all the discovery in this case. And this nonsense about Christina Fox and Stearns County, I have no idea what she's referring to. She was given police reports that outline what Christina Fox, what information she provided to the Lakeville Police Department. I have no idea what she's talking about in relation to Stearns County. And as far as Samantha's statement is concerned, Samantha testified at her mother's trial, and the court is well aware, and perhaps Ms. Evavold wasn't in the courtroom at the time, but the court is well aware of what Samantha's testimony was. And she clearly indicated that she was not forced to testify and that she was there on her own free will. And so this nonsense about pulling one little sentence out of Samantha's statement in support of a new trial is ridiculous.
Well, the motion for a new trial, the request for a new trial is denied. The issues that were raised by Ms. Evavold were repeatedly addressed during the course of the trial. And we will proceed to sentencing at this time. I do have some questions for you, Ms. Evavold. I recognize some of the people in the courtroom, but there are others that I don't recognize. Do you have any family members who are here in support of you today?
Yes.
I'm glad to hear that. During the course of the trial, you were essentially alone. And I'm glad to know that your family is here supporting you. I'm not sure. I know that Ms. Grazzini-Rucki is not here today. She was not present for you during the trial itself. I don't know if any of those people if there are those who encouraged you to take the actions you did, continue to support you. But I'm glad to know that your family is here, because they have been on this journey with you as well. And I'm sure that they love you and care about you. And when all of this is done, it's to your family that you will return. And this case is about family. It's all about family. During the trial, I was struck by the senselessness of your actions. Actions that have haunted each member of the Rucki family since April 19 of 2013. You have shown no remorse or understanding or comprehension of your actions. You have not demonstrated any comprehension of how your actions affected the lives of many, many people. Those most immediately affected the girls, their siblings, their father, their aunt, grandmother, but also the extended family members, friends, and the entire community. These children were missing for 944 days. Your actions directly disrupted another family for 944 days and longer, because the girls have experienced psychological fallout from their experience, their ordeal. The mother of these children was motivated by personal interest. But what was your interest in the Grazzini-Rucki family? You are a stranger to this family. The mother perhaps was motivated by animosity or malice towards the father. Perhaps her motivation was a misplaced belief that the girls weren't safe. But what motivated you to become involved? No, not to become involved in, but to intrude into the life of another family. Not friendship for the girls or with the girls. You never met them before the day they were taken from their home. Not friendship with their mother because you knew her only briefly. We're left to wonder if you were motivated by political persuasion, by distrust of the courts, by a desire to pursue an activist agenda of some sort. But whatever your motivation, the jury's verdict was clear. Your acts were illegal. You were the intermediary. You made it possible for these children to be secreted away from their father and siblings for 944 days. At any time during those 944 days, you could have changed course for the better of the children. You could have informed the authorities about their whereabouts. But when the authorities asked, and they asked you on more than one occasion, you denied knowing where the children were when you knew full well. You could have pursued your agenda, whatever that agenda may be, in a legal, productive way, through legal activism. Instead, you took matters that involved another family into your hands. You violated boundaries, but that's not why you're being sentenced. You're being sentenced because you violated the law. The family is the cornerstone of our society. As I said in the sentencing of one of your co-defendants, I'm not a psychologist, I'm not a social worker or an expert on child development, but I am a mother, a grandmother, and a judge. And I believe without hesitation, without a doubt, that our community, our children, these children, need and deserve the guidance and love that a father brings to their lives. Mr. Rucki was deprived of parental rights to two of his precious children for 944 days. And he is recognized in the law, as is their aunt who had custodial rights, as the victims of these offenses. But the ripple effect is clear. The other victims, the secondary victims, if they can be called that, are the girls and their siblings and the other family members who are left behind. In sentencing you today, I try, to the best of my ability, to base your sentence on the facts of the case, taking into account all of the circumstances that are legally relevant. My sentence is based on the facts and the law, and I strive by this sentence to do justice, which is a concept on which reasonable people can differ, but one that is based on fairness, on accountability, and on community standards, as those standards are articulated in law. So having been found guilty following a jury trial of all 6 counts of deprivation of custodial or parental rights, I am now going to sentence you The starting point for determining your sentence is the Minnesota Sentencing Guidelines. The Minnesota Sentencing Guidelines establish presumptive sentences that specify the duration and type of disposition. The sentencing ranges provided in the guidelines are presumed to be appropriate for the crimes to which they apply. And under Minnesota law, judges are instructed to pronounce a sentence within the applicable range unless identifiable, substantial, and compelling circumstances exist to support a departure from the range on the guidelines. Deprivation of parental rights is a severity level 1 crime. You stand before the court with a criminal history score of 0. The Minnesota Sentencing Guidelines call for a presumptive stayed sentence of 1 year and 1 day on these offenses. In other words, the sentencing guidelines presume a probationary sentence, and I will follow the guidelines set forth in the Minnesota Sentencing Guidelines for this sentence. So having been convicted of count 1 of depriving another of parental rights, you are adjudicated guilty of that offense. I am sentencing you to serve 12 months and 1 day in the custody of the Commissioner of Corrections. I am staying the execution of sentence, and you are placed on probation to the Dakota County Community Corrections Department for a period of 4 years. Having been convicted in count 3 of depriving another of parental or custodial rights, you are adjudicated guilty of that offense. You are sentenced to serve 12 months and 1 day in the custody of the Commissioner of Corrections. Execution of sentence is stayed, and you are placed on probation to the Dakota County Community Corrections Department for a period of 4 years. Your probationary period on count 3 will run consecutive to your probation on count 1. Your total probationary term is a term of 8 years, and you will not receive an early discharge from probation. Should your prison sentences be executed, they will be served concurrently. The terms of your probation on count 3 are identical to the probation conditions on count 1. The terms of your probation are these. You will serve 180 days in the Dakota County Jail. You will receive credit for the 44 days you have actually served. You will pay restitution to the Minnesota Crime Victims Reparations Board in the amount of $10,000. You will also pay restitution for any past or future uninsured counseling expenses incurred for therapy provided to the children, for all 5 of the children, and for family reunification therapy if such a claim is made. Restitution will be determined by the Dakota County Community Corrections Department, and your restitution obligation is joint and several. In other words, you will share it with your co-defendants. On count 1, you will pay a fine of $944, $1 for each day SVR was missing. You will pay the $80 surcharge imposed by law. On count 3, you will pay an additional fine of $944, $1 for each day GJR was missing. You will have no contact, direct or indirect, with Deirdre Evavold or Tammy Love. You will have no contact with SVR or GJR or any of the Rucki children, be they adults or minors. You will have no contact with minor children from other families. So you will not be allowed to have contact with other minors from other families. You will have no contact with your co-defendants, Sandra Grazzini-Rucki, Gina Dahlin, or Douglas Dahlin. You will participate in a forensic psychological evaluation and you will follow its recommendations and participate in any counseling, treatment, or programming that's recommended by the psychologist. You will follow the rules of the probation department and provide a sample of your DNA. The Dakota County Community Corrections Department is authorized to release the PSI report and psychological evaluation report to any court-ordered program. There are 10 standard conditions of probation that apply to your case, and you will find them detailed in the sentencing order. You will complete a cognitive skills evaluation and abide by its recommendations and participate in any programming recommended. You will cooperate with the transfer of your probation to your county of residence. You will abide by any restraining orders that exist either now or in the future. And that includes orders for protection, harassment, restraining orders, or any other civil restraining order that prohibits you from having contact with any person or going to any place. You will make no reference to any member of the Rucki family, and that includes the children, Mr. Rucki, Ms. Love, any member of the Rucki family. You will make no reference to them in your use of social media. You are adjudicated guilty of counts 2, 4, 5, and 6, and no sentence is imposed on these counts. Do you understand?
Yes.
We will provide you with a copy of the sentencing order. We will prepare a sentencing order. We will provide you with a copy of it today, and you are remanded to the custody of the sheriff. Thank you.
All right.